We are recording.
Okay, thank you, Lori. Good morning. The second case that we're hearing this morning is BOYAJIAN versus Planning and Zoning Commission of the Town of Vernon, AC number 43273. We are conducting this hearing via the Microsoft Teams platform, and the argument is also being streamed live on YouTube. Because of that, and I don't think it really implicates this case, but I just ask counsel and the court to be careful not to disclose any information that is confidential or otherwise protected by statute. Don't think it applies in this case, but I say it out of an abundance of caution. The first order of business is to have everyone introduce themselves so that we can make sure that everyone can see and hear each other. We'll start with the court and then counsel. I'm Judge Prescott.
I'm Judge Suarez. I'm Judge Vitale.
Good morning, Your Honor. My name is Lou Spadaccini, and I represent the appellee Planning and Zoning Commission of the Town of Vernon.
And good morning, Your Honors. I'm James Howard on behalf of the appellants.
Okay. Before we begin the argument, I wanted to raise kind of two issues with counsel about my participation in this appeal. It just became apparent to me when I logged onto the screen, and so let me put two things on the record and see if counsel has any concern. The first is that Attorney Howard, you have moved firms now. Is that correct?
No, Your Honor. The name of the firm has changed, but we're the same old firm since the 1980s.
Okay. And the reason why I raised that is many years ago, probably at least 20 years ago, I briefly consulted Attorney Howard with respect to my divorce that was pending at the time. Attorney Howard never ever entered an appearance for me. I think we spoke maybe briefly on the phone at one point. I don't even know if Attorney Howard has a recollection of that. I think this has come up maybe in one other case that I've been on in the appellate court. But I wanted to put it on that record and see if either one of you have a concern about me participating in this case.
I do not, Your Honor.
And I do not, Your Honor.
Okay. The other matter is that this case involves Riley's Liquor Store, and my former executive assistant at the Attorney General's office, her name is Melissa Gordon, at one point was employed on a part-time basis by Riley's, and she no longer works there. Do either of you have any concern about that?
I do not, Your Honor.
I do not, Your Honor.
Okay. All right. Thank you both. And so with that, we'll begin the argument. The appellant will have 20 minutes to argue, as will the appellee. If the appellant wishes to reserve any portion of the 20 minutes for rebuttal time, please let me know when the argument begins. And when you're running out of time, I'll hold up one of these kind of low-tech signs. Attorney Howard, are you ready to go?
I am, Your Honor.
Okay. And the other thing I'll just say before you begin is please keep your cameras on at all times. That's how we know you're still participating. But when you're not speaking, please mute your microphones so that we can eliminate any background noise. All set.
Thank you, Your Honor. Good morning, Your Honors. May it please the court. I'm Attorney James Howard from the firm Ferentino, Howard and Patron in Manchester, Connecticut, representing both of the appellants in this matter. And the major question that I think Your Honors will be wrestling with today is, why should this appeal be sustained when no appeal was taken from the underlying ZBA action?
Attorney Howard, do you want to reserve any rebuttal time?
And I would like to reserve 5 minutes for rebuttal. Thank you for inquiring, Your Honor.
You got it.
All right. So why should this appeal be sustained when no appeal was taken from the underlying ZBA action? And I would suggest that there are two presumably rare factors of this case that suggest that this is the case in which this attack on the underlying variance should be permitted. And the reasons for that is that we have an unusual situation in which the purported reason for granting the variance is plainly not allowed. And that is that the variance itself says that it's being granted due to building location, which there, and it's indicating that the hardship is the building location. And the statute 8-6 contemplates variances being granted for demonstrated hardships within particular zoning districts, and the statute does not authorize the granting of a variance simply because a building is located within the pertinent prohibited area. And that's what happened in this instance. So we have cases cited in the brief, the Dolan case, which involves a liquor store, and the Gregorio case, which involves a gas station, and it's protected. I refer to it as the buffer in terms of the terminology, the 3,000-foot buffer, in some instances 1,500 feet, 500 feet. But the Dolan case relating to liquor stores and the Gregorio case relating to gas stations, going way back to the 1960s in the Supreme Court, say that the location within the prohibited area is not a hardship and it cannot be a reason for the granting of the variance. And that's what we, yes, Your Honor.
Attorney Howard, you don't claim, I assume, that your client did not receive any required notice by the Vernon Zoning Board of Appeals with respect to the variance, I'll call it the variance proceeding or application.
That's correct, Your Honor, because in these buffer situations, there is no required notice to the owner of, let's call it what it is, a competing business that generates the buffer measurement. So they have to give their notice to the abutters, people within 100 feet. My client and the Riley's liquor store are not within the required notice, so he did not receive any notice. There was publication in the paper. The record does reflect that. And my client testified at the trial. The transcript is in the record that he, in fact, watches very closely the Planning and Zoning Commission meetings, because he does try and actively oppose anybody that is applying for a new liquor store application in Vernon. But he was unaware that there was another fight that potentially needed to be or watched out for, which would be the Zoning Board of Appeals. So he testified that he didn't have any knowledge of what the Zoning Board of Appeals did. So what that leads to with no notice and no appeal being taken is that only 2 months later, the second required step had to be taken by this applicant for a liquor store, which was to then approach the Planning and Zoning Commission for a special permit. And I would suggest that the reason why that's significant in this instance is that there could be no justifiable reliance by the recipient of the variance when there was another step that had to be taken before the liquor store could possibly operate within the town of Vernon at the location that was selected. So when we look at the Upjohn case, in which the Supreme Court indicated that there could be exceptions to the bar on what it called collateral attack on an unappealed zoning decision, that we should be within that exception in this rare case, because as the Supreme Court said, one of the factors is could there be justifiable reliance on the granting of the permit, which would make it unfair for someone to collaterally attack whatever the zoning board did several years later. And that's why we think this is the case that actually fits within the exception of Upjohn, because this particular applicant needed to go to the Planning and Zoning Commission before his liquor store could possibly be in operation. And as the record reflects, that due to this appeal and everything else, he never advanced his project whatsoever. So we know from the record that there was no reliance on the Zoning Board of Appeals granting of the variance because of the remaining steps that had to be taken. So we have it. The reason why we believe that this is finally, I believe Upjohn was 1992 and suggested that there could be an exception to the bar on collaterally attacking a zoning decision, that this is finally the case where the exception should in fact apply, because we have a clear deviation from what is jurisdictionally allowed for a variance, and we have no justifiable reliance because of the essentially almost immediate need for an additional permit from the Planning and Zoning Commission. So that's why we contend that we are within the Upjohn exception, and this is an opportunity for the court to finally say that there is a case that fits within that. I would also suggest, Your Honors, that the Planning and Zoning Commission should be required in and of itself to look at the underlying variance and make a determination of its validity. And in this instance, you will see in the record, the transcript of the hearing before the Planning and Zoning Commission, that the town planner actually told the commission it disregard, or you can ignore is probably too strong, but the town planner was suggesting that the Planning and Zoning Commission had the authority to apply the regulations despite what the Zoning Board of Appeals had done. And
that's a legal question ultimately, isn't it, for us to decide rather than someone's testimony that they could do it?
Well, I think that at the zoning level, it is appropriate for when there have to be these sequential permits for the zoning board that comes next in line, whether that be planning and zoning, inland wetlands, whatever the sequence may be, that they do have a requirement to at least minimally review what the other boards have done, and if they can get a legal opinion from their town attorney. It was not Attorney Spadaccini at the time, who's with us now, but they can get an opinion from the town attorney regarding the validity of the actions of the other boards, and that's what should occur, because the Planning and Zoning Commission does have its own independent obligation to review the application. So I would direct Your Honor's attention to the Moskowitz. Well, actually, it's really the Indian Spring versus Greenwich, which is 322 Connecticut 1. This was not cited in my brief, Your Honor, in which there was a review about whether the Inland Wetlands Commission
Can you give me the site again?
Sure, it's 322 Connecticut 1.
Thank you.
And what was reviewed in that situation was whether an inland wetlands agency had the jurisdiction to decide whether a gravel road was within the inland wetlands exception for farming activities. And it was determined that by the Supreme Court that the Inland Wetlands Agency, because of those particular activities that were planned and in the record, did not in fact have jurisdiction to deny or even review any permit application by that the applicant had made. And so what that suggests, when that's an inland wetlands agency, is if another board were then required to do any permitting or would be involved in that, which seems to happen in an awful lot of these applications these days, then it certainly would be within the purview of the other reviewing board to say, you didn't have jurisdiction to do X, Y, Z, and therefore we're still going to apply the regulations and either grant or deny the permit, which in this instance would have simply been that the Planning and Zoning Commission, as the town planner had suggested, could have said the 3,000-foot buffer between liquor stores was legislatively determined and adopted as a regulation of the town of Vernon. The Zoning Board of Appeals does not have the jurisdiction to rewrite that particular zoning law, and therefore we're going to apply that regulation and deny the special permit. And that's what, in fact, should have happened in this instance. But that did not happen. Instead, the Planning and Zoning Commission, as the record reflects, believed that it was entirely boxed in its review of this application because the retail plaza where this new liquor store was going to be located had been approved in 2016. It was now 2 years later that the variance was granted and the application for special permit went in. So in terms of the location of the building, the site plan, the traffic considerations, all of those issues had been resolved long before any issue came up about it being the location for a liquor store. So what applicants' counsel represented to the Planning and Zoning Commission was there are no issues left, and obviously I'm paraphrasing, but there are no issues left regarding the traffic, location, nature of building, nothing's left, and you cannot apply the 3,000-foot buffer prohibition because a variance was already obtained from the Zoning Board of Appeals. So there was nothing left for the Planning and Zoning Commission to review. The case that I would primarily rely on in this instance is an appellate court case, the Moskowitz versus Sherman, which did, the Planning and Zoning Commission of Sherman, I should say, which did allow a challenge to what was determined to be a void restriction that was placed on a PZC approval. And I would simply note that a close reading of Moskowitz certainly supports the appellant's argument in this instance that the ZBA variance was beyond the jurisdiction of the ZBA, and the Planning and Zoning Commission should have, in fact, denied the application because of the violation of the 3,000-foot buffer. So if your honors have no further questions for me in this segment of my presentation, I will step aside and return for my 5 minutes of rebuttal. Thank you, your honors.
Thank you. Attorney Spadaccini.
Thank you, your honors. May it please the court, my name is Lou Spadaccini. I'm with the law firm of Blackwell and Spadaccini, and I represent the appellee, Planning and Zoning Commission of the Town of Vernon. This court should affirm the trial court's decision upholding the special permit granted to Jagdev Tour because the appellant failed to appeal the 65-foot variance of the separating distance between sellers of alcoholic liquors when it was first granted by the Vernon Zoning Board of Appeals. The appellant had a full opportunity to participate in and appeal this decision, but did not do so. I agree with counsel.
Attorney
Yes, sir.
Spadaccini, your argument, I assume, is that the newspaper publication was sufficient to put Riley's on notice of this proceeding in front of the ZBA for a variance, even if no other kind of statutorily required notice was given. Is that correct?
That's correct, Your Honor.
All right, go ahead.
The dispositive case here is the Upjohn Company case from 1992. And there are several relevant provisions of that case. I'm sure the courts, I won't recite them all, but Upjohn's been elaborated on since the Supreme Court in Torrington versus Zoning Commission of the Town of Harwinton elaborated that, as the language in Upjohn indicates, it must be an exceptional case that will justify disturbing the stability of unchallenged land use decisions. It is not enough that the conduct in question was in violation of the applicable zoning statutes or regulations. It must be shown that the conduct was so far outside what could have been regarded as a valid exercise of zoning power that there could not be any justified reliance on it. Thus, the litigant who seeks to invoke this exception must meet a very high standard. And I have to respectfully disagree that this is not finally the case. This case doesn't even come close to meeting that high burden. And the reasons for that is that in the matter at hand, it's undisputed that the appellant had the opportunity to litigate the validity of the variance at the time it was granted. The Vernon ZBA's lack of jurisdiction is not entirely obvious, nor is the variance so far outside what could have been regarded as a valid exercise of zoning power. In fact, the trial court held that the appellant's claim that the ZBA lacked authority to grant a variance, or the variance, is far from obvious. And further added, it is clear that such an appeal...
Attorney Spadaccini, what's unclear about the statute, the language in 4.9.5? Under no circumstances shall the ZBA grant a variance to allow a use in this district that is specifically allowed by the Planning and Zoning Commission under section 4.94.
That, I think that applies as a general, as the trial court pointed out in their decision, that does not go to the ZBA in granting this use variance, granted for one property. It didn't grant it for any group of properties or as an overall generality. It granted it. It was one specific variance of a distance and a minor variance at that. The court noted that, had this been appealed properly, it would have presented a colorable claim, but both parties offer good arguments for their respective positions. The ZBA is the only agency that has the authority to vary the distance between sellers of alcohol. Connecticut General Statute 8-6 grants zoning boards of appeal the exclusive power and authority to determine and vary the application of the zoning bylaws, ordinances, or regulations. So there's no clear lack of jurisdiction for the ZBA's actions. The court should not regard a variance of just 65 feet on a 3,000-foot separating distance as being so far outside the ZBA's jurisdiction that there could not be any justified reliance upon it. The argument being presented by the appellant is not really whether the ZBA had authority or jurisdiction over granting such a variance, but whether the ZBA properly exercised its jurisdiction. And as such, the action's merely voidable and only when an appropriate appeal is taken. This is the distinction that was drawn in Moskowitz versus Planning and Zoning Commission of the Town of Sherman. The appellant's reliance on Dolan versus Zoning Board of Appeals for the Town of Fairfield is also misplaced for the proposition that the location of the property is not a legal basis for granting the variance. But Dolan does not hold that that is always the case. And Dolan involved an appellant who properly appealed the variance from the ZBA's decision. Dolan did not involve a collateral attack on a zoning action. And once again, the distinction drawn in Moskowitz comes into play. At best, the appellants in the matter at hand have an argument as to whether the ZBA properly exercised its jurisdiction, but not whether the ZBA had the jurisdiction to vary the distance between sellers of alcohol. This does not meet the very high standard set by the Upjohn Court. The ZBA did not authorize the establishment of any use, nor did it usurp the special permit authority of the Planning and Zoning Commission. The ZBA simply varied the separating distance between sellers of alcohol. The use was still subject to the special permit process, which contains several criteria other than distance between sellers. Those criteria are set forth in the trial court's decision and in section 17.3 of the Vernon zoning regulations, which can be found in the record at page the appellate record at page 142 of the appendix to the appellant's brief. Lastly, no strong policy reasons exist for giving the appellant a second opportunity to contest this variance. We're talking about a variance of just 65 feet of a 3,000-foot separating distance between sellers of alcohol. The package store is still 2,935 feet from its nearest competitor. The record reflects that at the time of the hearing on the special permit, none of the 8 package stores located in the town of Vernon were in compliance with the 3,000-foot separating distance. And this can be found in the record at page 120 of the appendix of appellant's brief. Any fear of the town of Vernon being suddenly overrun with liquor stores because of this variance is misplaced, because Connecticut General Statute section 30-14A limits the Department of Consumer Protection to issuing 1 package store permit for every 2,500 residents in a town. And as shown, as reflected in the record, this means that the most package stores the town of Vernon could have is 11, and they were at 9 in business at the time of the variance application. This can be found on page 92 of the appendix of the appellant's brief. The record also reflects that most of the surrounding towns have far less restrictions on the location of package stores, and several have no restrictions at all. If you read the transcripts of the 2 hearings in the appendix to the appellant's brief, it's very clear that the 3,000-foot buffer between liquor stores served little purpose in limiting the number of package stores in the town. Its primary effect is to limit the location of competitors to existing liquor stores. And compare that reason or that justification with the language in Upjohn, with the town of Torrington case. I doubt that meets the very high threshold of strong public policy grounds set by the Supreme Court. So in conclusion, the Zoning Board of Appeals had jurisdiction, and its exercise of that authority was not so far outside the confines of its variance granting authority to justify the extraordinary remedy, or the remedy that's available in extraordinary cases, I should say, reserved in Upjohn. The Upjohn case, they made a point of saying that they've reserved this remedy for cases where no notice was provided at all of the zoning hearing or proceedings. And that makes sense, because if there's no notice whatsoever, there's no opportunity to contest it. And they said, you know, there may be other extraordinary circumstances, but if you look at the facts and what was done in this case, I beg to differ that this is the case that that the court in Upjohn was envisioning when they created this exception. Thank you, Your Honors.
Okay, Attorney Howard.
Okay, I'm back, Your Honors. Thank you. What we did not hear from the town of Vernon was any attempt to highlight anything in the record that suggests that there was a hardship that justified the granting of this variance. And that's simply because there was never any attempt to suggest by the applicant or anybody else that there truly was a hardship. The only indication at the ZBA hearing was that the property owner couldn't pay the taxes unless he got tenants. And then the economic development director for the town of Vernon testified that the 3,000-foot buffer regulation was antiquated and had outlived its usefulness. That's in the appendix at pages 99 to 100. And those are not determinations for the ZBA. That's the legislative function of creating the regulations. And Vernon had decided that it wanted to have this 3,000-foot buffer. And yet it's now Vernon itself that is attacking the 3,000-foot buffer as somehow being a bad policy that should be varied. I would also like to point out that the nature of the variance is that it's now going to create a 3,000-foot buffer around the new liquor store. So even though the town suggests essentially what's the big deal with a 65-foot variance, it is a big deal when the new store then projects its own 3,000-foot barrier further up the commercial strip that is Route 83 in Vernon. Perhaps, I mean, it's sort of a smaller version of the Berlin Turnpike, that type of a road. And to put a new liquor store and project a new buffer has an impact beyond just the property that was seeking the variance. And the power granted to the ZBA in 8-6 says that you're only supposed to focus solely on the property in question, and the nature of this variance does far more than that. I would suggest, in terms of the town's argument that this was a discretionary approval of the variance rather than a jurisdictional issue, that's incorrect. That this application in the record says that it is being sought because of the building location. That is it. And that is the equivalent legally when 8-6 is applied of saying the reason for that the hardship is none. They just want it in order to be able to run a liquor store at that location. And I would suggest to your honors that if they had in fact listed on the ZBA application that the hardship was none, that your honors would have no difficulty in suggesting that that was a void variance when it was subsequently granted. This case is exactly the same because of Dolan and Gregorio and 50 years of case law saying that you can't change that buffer to indicate on your variance application that the reason or the hardship is building location is the equivalent of saying none. We have no hardship. That amounts to a jurisdictional defect based on the powers granted to the ZBA under 8-6 and should not be allowed to stand. So if your honors have no further questions for me, I will rest on the brief and thank you for your time this morning.
All right. Thank you both. That was very well argued by both of you. I appreciate it. I look forward to seeing you back in the real courtroom at some time soon. And with that, we stand in recess.
Thank you, Your Honor. Thank you, Attorney Spadaccini.